incompatible with the text of Winter. In Winter in 2008, this court reaffirmed the four-part traditional test for injunctive relief, with four prongs to be met independently. This traditional standard requires that the movement show, among other things, a likelihood of success on the merits. The serious question standard is incompatible with this test, as it does not require a movement to show their likelihood of success on the merits. It merely requires the movement show that there are serious questions going to the merits of their case.
Can you just tell me really quick what the standard of review is here?
Absolutely, Your Honor. The standard of review for a granted preliminary injunction is abuse of discretion. We know that from Alliance for the Wild Rockies versus Caldwell, a Ninth Circuit case from 2011. We know further that a district court necessarily abuses its discretion when it applies the incorrect legal standard. We know that from Arnold versus GE Capital from the Sixth Circuit. So here, where the district court has incorrectly applied the serious question standard, they have necessarily abused their discretion in this case. Now, if there was any doubt that this court's holding in Winter abrogated the serious question standard, we can look to this court's holding in Moot versus Jared a mere few months prior, where this court again declined to apply the serious question standard and again applied the four-part traditional test, stating, a difficult question as to jurisdiction is, of course, no reason to grant a preliminary injunction, as it says nothing about the likelihood of success on the merits. Now we're back again for the third time to answer the same question that this court has already answered twice. Opposing counsel may point out that Moot versus Jared merely dealt with a jurisdictional issue. However, there is no principled reason for this court to treat jurisdiction any different than a question on the merits.
Can you share what likelihood of success means exactly?
Certainly, Your Honor. We would advance the definition of the American jurisprudence on injunction, second edition, section 18, where they define this likelihood of success as a reasonable probability. So in this case, for the prong of likelihood of success on the merits, a reasonable probability that after a full adjudication on the merits, the moving party will succeed. In Winter, this court rejected a possibility of irreparable harm. The serious question standard does not even meet the threshold of a possibility. If this court declined to allow an alternative standard of possibility, it should de facto decline to adopt this serious question standard. Irreparable harm cannot be the determining factor for injunctive relief because injunctions harm both parties. Both sides have legal rights. Anytime a law is passed, personal liberties are infringed upon. And any time that the court enjoins a duly enacted legislative statute, the state is harmed because their legislative power is usurped. This requirement of a clear showing of likelihood of success on the merits allows for equity in the law. People are not entitled to relief merely because they are harmed. We do not have a strict liability justice system. But because this is an equitable remedy, we must hold movements to the traditional standard of satisfying a likelihood of success on the merits.
So what is that standard meant?
The standard will be met whenever the movement shows that after full adjudication on the merits, they will succeed on their claims, or they will most likely succeed on it. I would point against this reasonable probability.
Well, isn't the standard that you're advocating for like preliminary injunctions, the cases that are very simple or straightforward? I mean, what about the cases where the district court may not be able to determine with 100% certainty whether the moving party will prevail on the merits, but the costs significantly outweigh the benefits of not creating the injunction to wait and see what happens?
To answer your question in two parts, Your Honor, this will absolutely restrict injunctive power, and it should, because preliminary injunctions are an extraordinary and drastic remedy, which this court said in Winter and has repeatedly reinforced over the years. And to answer your question, pardon me, could you repeat the second part of your question, Your Honor?
Sure. Well, what if the district court can't determine with 100% certainty at the preliminary injunction stage, that the moving party will prevail? Does that mean That's the only time that the preliminary injunctive relief can be granted when it's absolutely this clear-cut case. And what if the costs significantly outweigh the benefits of not granting the injunction to maintain the status quo and see what happens?
I take your point, Your Honor, but in line with the text of Winter and this court's prior holding in Moot versus Jared, this court should require all 4 factors to be met, whether or not the balance of equities tip in the favor of the movement. Because this court's traditional jurisprudence requires that each 4 factors be met independently. And to my second point, Your Honor, having multiple injunctive standards presents an unworkable framework. Varying alternative standards assist in unjust application of the law from circuit to circuit. There is no uniformity or consensus on what the correct injunctive standard is. This court should reaffirm their holdings in Winter and in Moot and require that all 4 prongs be met independently. Furthermore, this presents a dual line drawing problem for courts. Firstly, what is a serious question? The last definition that we have of a serious question is from the Second Circuit in Hamilton Watch Company versus Fenris back in 1953. There, the court described a serious question as one so substantial, so difficult, so doubtful as to create fair ground for more deliberative investigation. This is a mere amalgamation of more subjective and undefined terms. It is simply too amorphous a standard for district courts to apply equitably. And to your point, Your Honor, a court cannot determine with certainty that a movement is likely to succeed on the merits. If we were to allow this serious question standard, or say questions of first impression, that will incentivize litigants attempting to present everything as a question of first impression, instead of qualify for this relaxed standard. And furthermore, litigants do this all the time. Is it really a question of first impression, or does it just present different facts with the same with already settled law? We even see this with the Mariano's claims. They assert that this is a question of first impression. However, this has been decided by this court in Gonzalez versus Carhart in 2007, where it said that the state has the authority to ban uncertain medical treatments. The only change in this case is the facts. Here we have transgender youth seeking gender affirming care, but it's the same legal principle that has already been settled by this court in Gonzalez versus Carhart. States have the authority to ban uncertain medical treatment. Even if this court finds that the serious question standard is permissible, it is unworkable for laws enacted for the public benefit. We know this from Yakis versus United States from this court in 1994, where an injunction will adversely affect the public interest. It is permissible and even advisable to withhold relief until a final determination of the rights of the parties, more freely than when only private interests are involved. Both the Second Circuit and the Eighth Circuit in Abel versus United States.
Let me ask you, if the purpose of a preliminary preliminary injunction is to maintain status quo until trial, why doesn't that favor the family?
Well, Your Honor, I want to point out that the Marianos do not only want to maintain the status quo. If we look to the record on page 5, Jeff's psychiatrist has testified that Jeff may require top surgery or removing the breast tissue from Jeff Mariano's chest prior to the age of 18. Jeff Mariano does not merely want to continue to receive puberty blocking treatments. He wants to up the ante and get more. And furthermore, nothing in the record has presented sufficient evidence that by Jeff Mariano not receiving these puberty blocking treatments anymore, that this will substantially change his mental state.
And why was there strong evidence of the preliminary injunction here that gender dysphoria left untreated can have serious negative health consequences, including anxiety and depression? What if the preliminary injunction had been denied and just committed suicide before the court could hear the case?
Your Honor, we concede that anytime a minor takes their own life, it is absolutely a great form of irreparable harm. However, there is simply insufficient evidence in this record to indicate that Jess Mariano will take its own life. And furthermore, we look to Eckes Tucker versus Marshall, which is a middle district of Alabama case from this very year. We know that irreparable harm cannot be remote or speculative. And asserting that Jess Mariano will commit suicide if he is no longer able to receive this gender affirming care is simply far too remote and speculative. And furthermore, Your Honor, that is why the state of Lincoln has written this same act to allow youth who are already receiving gender affirming treatment to taper off their medications, as we can see on page 12 of the record. And furthermore, the state is not foreclosing these gender dysphoric youth from receiving traditional psychotherapy, which is the approved method of treatment for gender dysphoria by the FDA. Finally,
Counselor, when you're talking about well, procedurally, didn't the district court make findings of fact about regarding this? It's one thing to have a standard review for the question of law, but are we to disturb the findings of fact in the district court as well?
this court is within its discretion to either accept the district court findings of fact or substitute their own findings of fact, Your Honor. To my final point, a more relaxed standard undermines the extraordinary nature of injunctive relief. In winter, this court recognized that injunctive relief is an extraordinary and drastic remedy, and this remedy must remain extraordinary because it gives district courts the power to enjoin potentially lawful action on the parts of the non-movement before the parties have the opportunity to present the merits of their case at trial.
But Winter did not overrule the sliding scale approach, did it?
Not explicitly, Your Honor, but implicit in its holding, where this court said that we cannot allow flexibility on the prong of irreparable harm, and implicit in this court's holding that we cannot allow the serious question standard for a jurisdictional issue. It is the holding that the serious question standard is impermissible as an alternative standard. Furthermore, we know from Kennedy versus Boulder from this court in 2009 that this extraordinary remedy must be granted sparingly. And it is for these reasons that we ask this court to vacate the preliminary injunction. Thank you.
Thank you. You may proceed.
Madam Chief Justice, and may it please the court. My name is Haley Bray, and today I will be addressing the second question before the court, which is why the preliminary injunction was improperly granted in regard to respondents' constitutional claims. Your Honors, at stake in this case are the very principles of federalism and state sovereignty as contemplated by these nations' founders. This court should render judgments in favor of petitioner for three reasons. First, the Marianas are unlikely to prevail on the merits of their substantive due process claim because they cannot clearly show that a fundamental right was violated. Second, the Marianas are unlikely to prevail on the merits of their equal protection claim because the act does not discriminate against a protected class. And third, because the balance of hardships tips in Lincoln's favor, regardless of what injunctive relief standard this court imposes as to the first issue, the Marianas are not entitled to relief. As to my first point, Your Honors, the Marianas are unlikely to prevail on the merits of their substantive due process claim because parents do not have a fundamental right to access specific medical treatment for a minor child that may be harmful. We concede that parents have a general right to direct the health care of their child. However, as noted on page 29 of the record,
So does that mean we are to never engage in experimental treatments?
no, Your Honor, that is not what that means. As noted on page 29 of the record, whenever a treatment is harmful, it puts the mental or physical health of the minor child at risk. The state is with some discretion over parental decision making. A great illustration of this comes from the Ninth Circuit in 2014, Hiccup versus Brown, where the Ninth Circuit upheld a district court finding that there was no fundamental parental right to obtain specific medical treatment where the state had deemed the treatment harmful. At issue in
And
that
that decides the healthcare professional or the legislature who should decide that.
Your Honor, per this court's decision in Gonzalez versus Carhart, whenever there is medical uncertainty as to the safety or efficacy of a treatment, the legislature could be given deference. And that's exactly what the court held, or the Ninth Circuit held in Pickup versus Brown. There was a California state law that banned sexual orientation change efforts or social therapy for minor children. Now, in the 2 previous decades before this case went to court, this was an accepted medical treatment. However, responding to studies that came out in the early 2000s, the California state legislature decided to ban these treatments when applied to minors. The parents sued, stating a fundamental right to obtain these treatments for their children. However, the Ninth Circuit held that it was a legitimate, if not compelling, interest for the state of California to ban these treatments, as the risks to the many minors of the state were vast, and that outweighed the parental right of deciding what medical treatment their child should receive.
Well, Counselor, in this case, the district court made its findings that the treatment is not harmful, and that the child is in danger going forward if the statute remains in place. Isn't the district court in a better position to make those findings of fact and weigh that evidence than we as an appellate court, just reading a record?
No, Your Honor, we contend that that is not the case. As noted by Justice Gilmour's dissent, at the appellate court level, the trial court did not give due regard to the state's arguments about state sovereignty, nor did it give due regard to the risks associated with these treatments. There is no medical consensus as to the safety or efficacy of these treatments. As noted on the right,
They're cutting edge treatments, right? I mean, we can always find a doctor that disagrees with the particular treatment, can't we?
yes, Your Honor, but in this case, studies that are cited on pages 7 and 8 of the record, footnote 3, indicates that Sweden, Finland, and England are rolling back their gender affirming care policies in regards to minors. Now, these are countries that have been far ahead of the United States whenever it comes to research about gender affirming care. Unfortunately, the domestic research just hasn't caught up. And studies cited by respondents reflect this, including the Bride study, cited on page 7 of the record. Within that study, it itself admits that it is faulty due to having a small sample size and relying on self-reporting to indicate the risks associated with it.
Can I ask you a quick question? Does the same act ban all medical puberty suppression?
No, Your Honor. The patients are still able to receive psychotherapy. They can still go through a social transition, and we would not want to characterize this as a ban, but more of a waiting period. Which brings me to my next point. The Marianas are unlikely to succeed on the merits of their equal protection claim because the act makes a distinction based on age, not gender identity. In Massachusetts Board of Retirement versus Murgia, this court held that the Equal Protection Clause of the 14th Amendment allows statutes to classify individuals based on age due to certain psychological and physiological differences between the age groups. As noted on pages 2 through 4 of the record, both the text of the statute and the legislative findings are primarily concerned with the age of the patient. Age is the decisive factor in this case. If we take a step back and look at the policy behind this, it is no different, but is it?
Because does the act allow the same exact treatments for non-gender dysphoria reasons?
Yes, Your Honor, but that is an entirely different issue because puberty suppressants are approved by the FDA to treat precocious puberty, and they have been since 1993. However, the FDA has declined to approve these same treatments for gender dysphoria. And while the record is silent as to why that might be, it still raises serious questions about the safety and efficacy of these treatments. This is no different than a state prohibiting alcohol or tobacco for minors while allowing adults to obtain these products. It's not because states have determined that these are somehow safe for adults. They know that these are not safe for adults, just like the state of Lincoln knows that these treatments are still not safe for adults.
But in this situation, it's not a difference between children and adults, it's a difference between trans children and other children.
No, Your Honor, based on the text of the statute, which is where we can glean the purposes and is where we can glean the purposes of the act. It is focused primarily on age. Once Jess Mariano or any other minor within the state of Lincoln turns 18, they will be able to have access to whatever gender affirming treatment they want. And we believe that this is evidence of how narrowly tailored this statute is in its goal of achieving health and safety for the many minors of Lincoln. As noted by testimony on page 30 of the record, there are several problems with these treatments, namely harmful side effects, as testified to by Dr. Geller, the state's expert, and informed consent issues, as testified to by detransitioners themselves.
Legislature speak to anyone who had these treatments and had great success from them. And then another question before I forget it, you kind of seem to single out the United States, but WPATH is an international organization, right? And doesn't it support this?
Your Honor, as to your first question, I'm so sorry, would you mind repeating your?
So did the legislature talk to anyone who had this type of treatment before they turned 18 and had great success? Or do they just focus on people who maybe didn't?
Your Honor, the record is silent as to that, although it was a legislative public debate, so that certainly could have happened. The record is silent, and we do not want to advance that there were those opinions.
Okay. I fail to understand the logic here. You keep citing foreign data, the data of N equals 2 doctors who are testifying the inefficacy of these drugs for gender affirming reasons. But the American Medical Association, American Academy of Pediatrics, American Psychological Association, these are bodies of our country's medical authorities endorses this. So you have 2 doctors in 2 foreign countries, with citing controversy in its use. I mean, what's your thought on that?
Your Honor, the problem with the domestic studies is not the American Medical Association itself. It's that the research is so far behind that of Western Europe. And the state of Lincoln is well within its state's police powers to regulate in areas of medical uncertainty. Furthermore, a support from medical organizations does not per se create a medical consensus on a topic. Throughout this nation's history, there have been plenty of dangerous and harmful medical treatments that have been given to patients over the years that we look back on and see how harmful they actually were.
So the state steps in and uses its power. So is the state suggesting that we cannot trust the medical judgment of medical professionals? That's what it sounds like I'm hearing.
Your Honor, it's not the state's opinion that we cannot trust the medical judgment of medical professionals, but it is the state's position that their medical judgment is based on studies that are self-admittedly faulty. For instance,
We can't trust American studies.
no, Your Honor, it's not that we can't trust American studies. It's just that the American studies that have been going on as to this treatment are not long running enough, and they don't have large enough candidate pools, as noted by the Bride study on page 7 of the record. However, moving to my third point, no matter which standard is applied to the first issue, the court must still balance the equities, which tips in Lincoln's favor. Enjoining a potentially lawful statute injures the state irreparably because it denies the public their interest in meaningful democratic participation. The purpose of this act is to protect the health and safety of the many minors living in Lincoln, and this has to be balanced against the interest of one minor. What is in the best interest of the entire state has to prevail over what is in the best interest of one individual. And frankly, the record is silent on how many transgender minors live in the state of Lincoln. How many minors
Does that work against you as well? So what rights do parents have to determine appropriate care for their children? And trust the guidance of the medical professional.
Your Honor, parents do have the right to direct the health care of their child when it comes to safe and effective treatment. However, when a treatment is deemed harmful by the state has discretion over parental authority within that realm. The fact of the matter is, the harm cited by Lincoln is concrete. Kids will keep getting hurt by this treatment unless it is taken off the books completely.
That sounds conclusory to me.
Pardon me, Your Honor, I did not mean to sound conclusory. It is because parents do not have a fundamental right to obtain harmful medical treatment for their child. It is because the act does not discriminate based on gender identity. It merely classifies by age. And it is because the balance of equities tips decidedly in Lincoln's favor that we ask this court to reverse the judgment of the 15th Court of Appeals and render judgment in favor of the petitioner. Thank you.
Thank you. You may proceed.
May it please the court. My name is Josh Pointed, and I, along with my co-counsel Madeline Chittister, represent the respondent, the Mariano family. My co-counsel will be addressing the constitutional issue, whereas I'll be addressing the preliminary injunction issue. The decision of the 15th Circuit Court of Appeals is to be affirmed for two reasons. First, the serious question standard remains viable. Second, this standard ensures fairness, equity, and justice. Your Honors, anxiety and depression are invisible, but that doesn't make them any less important, real, or dangerous. As shown by the study on page 7 of the record, untreated gender dysphoria can lead to depression and suicide. These same studies show that 35% of transgender children have already attempted suicide, but gender-affirming care can lower these odds by nearly a third. As depicted on page 4 of the record, Jess struggles with depression because he feels out of place in his own body. Jess was born biologically female, but has felt like a boy his entire life. This caused such severe mental distress that at only 8 years old, he swallowed a handful of pills and told his parents that he never wanted to wake up again if he had to be a girl. Thankfully, he was able to get the help he needed in the form of gender-affirming care. But the state of Lincoln then attempted to ban these same life-saving treatments under the Stop Adolescent Medical Experimentations Act, as depicted on pages 2 through 4 of the record. Lincoln believed that speculative future harms from these treatments outweighed the known harms from no treatment that the Mariano family already experienced.
So can you help me understand why you don't think a preliminary injunction is overbroad? Is there any evidence that says your client needs to have surgery prior to the day of trial?
Your Honor, frankly, it depends, and I mean, I know that's the typical lawyer answer, but it depends on the doctor's discretion in his treatment. Just as Jeff started with counseling, when Jeff reached 10 years old, his doctor then decided that his counseling was not decreasing his depression, and in fact, his anxiety was beginning to increase due to female puberty. And at that point is when his doctor decided to prescribe puberty blockers. The same can be said for hormone treatments and even surgeries. The doctor will take these instances into account and make those decisions as they come, as it should be done on a case-by-case basis, as shown on page 7 of the record.
But doesn't that mean that we as the court would be, substituting our judgment for the judgment of the legislature?
No, Your Honor, and that's because we would be allowing the discretion to the parents and the doctors as opposed to the discretion of the court. And using the serious question standard would allow for a broader view of this case and allow this court and other courts to view all of the merits and all of the information of the case due to the flexibility of the standard.
So what makes the question serious?
What makes the question serious was stated in 2019 in the Second Circuit in Trump v. Deutsche Bank. The Second Circuit stated that a serious question must be at least a substantial fact question. In the Trump v. Deutsche Bank case, there was an injunction to enjoin the subpoena of bank records, but it was found that those bank records were allowed to be seized due to the public figure and the IRS code. The likelihood of success or the issue of the subpoena was therefore a matter of law, and that injunction was denied even under the serious question standard, showing that despite petitioner's contention, this is not a strict liability standard. Both of these standards, the traditional standard and the serious question standard, have been acknowledged by this court, and neither has been explicitly struck down, which brings me to my first point. The serious question standard remains viable. To address the two cases that petitioner cited, that from this court, Moot versus Guerin and Windsor versus Natural Resources Defense Council, in both of these cases, they did not explicitly speak to the serious question standard, and the serious question standard abides by both of them. In Moot versus Guerin, it was an issue of whether jurisdiction was enough to satisfy likelihood of success. That is not what the serious question standard is claiming to do. A substantial fact question is far more than simple jurisdiction. In Windsor, this court held that the possibility of irreparable injury was not enough to meet the likelihood of irreparable injury. It also stated that the purpose of this was due to the extraordinary nature of preliminary injunctions. The serious question standard abides by both of these prongs. First, it does not allow for a lower showing in the likelihood of irreparable injury. In fact, the showing is often more than the 51% required under the traditional test. Additionally, the serious question standard abides by the extraordinary nature of preliminary injunctions because it does not lower the burden on the movement.
What do you make of your opponent's argument that Jess can just resume transition when he turns 18?
Jess would not be getting relief in that scenario, or not be able to get relief in that scenario, because he would be subjected to irreversible harm immediately if this injunction were denied.
But how would there be irreparable harm if there are other forms of gender affirming care?
There would be irreparable harm because mental harms are in fact irreversible. There are treatments such as counseling and therapy to help mitigate the circumstances and consequences from depression. Those don't cure depression.
Aren't you just being speculative at this point, though?
No, Your Honor, because as shown on page 5 of the record, counseling stopped working for Jess once he went into female puberty. And denying this injunction and taking away his access to puberty blockers would put him back into female puberty, again, causing him more anxiety, more depression, and reversing counseling they already had, and potentially pushing him toward physical harms, including suicide. Additionally, the balance of hardships tips in favor of the movement. And essentially what the balance of hardships means is the severity of the harms. Irreparable harm must be actual and imminent. And the harm to Jess is exactly that. He would suffer these harms immediately, whereas the harms asserted by petitioner are far in the future and unknown when they will happen.
law was passed by the legislature, which consists of representatives of people. So aren't the people of Lincoln being harmed when a district court, one judge in one court prevents the state from effectuating the statute that was enacted by the legislature?
No, Your Honor, and that is because the public interest is also in favor of this injunction. The transgender youth are essentially in the exact same shoes as Jeff, and they will suffer these same irreparable harms immediately. Additionally, government action typically does have some deference toward the legislative process when talking of preliminary injunction. However, there's an exception to this rule whenever there's constitutional rights at stake and competing public interest. Whenever both of these prongs are met, the serious question standard in fact becomes required, as the Second Circuit stated in Time Warner Cable of New York versus Bloomberg. In Time Warner, the plaintiff's First Amendment rights were at stake, and the government was asserting that regulating TV was in the best interest of the public. But Time Warner asserts that no regulation was in fact in their best interest. We have a very similar situation here. The Mariano family has two constitutional rights at stake, including the fundamental right to direct medical care for their child and Jess's equal protection rights as a transgender individual.
So do they have a fundamental right to harm their child in a situation where the research suggests that the procedure is harmful to minors?
No, Your Honor, they do not have a right to harm their child. And that's often why in cases like this, a third-party fact finder, such as the doctor, is used as a third party to help make these difficult decisions. And this goes further to my co-counsel's argument, which she will discuss further. The serious question standard becomes required in this case due to the constitutional rights at stake for the Mariano family and the competing public interests between Lincoln and the Mariano family.
So let me ask you, are not preliminary injunctions extraordinary remedies? Why would we just not go to trial and if you win, damages?
Yes, Your Honor. Preliminary injunctions are an extraordinary remedy, and the serious question standard abides by this ruling by this court. And it's because it doesn't lower the burden. It requires a much higher showing in the second, third, and fourth factors to offset the lower serious question. And in fact, they become same average as the traditional standard and the same burden. But what the serious question standard does is create a more flexible test without lowering this burden. And this allows for a wider lens to see more unique, complex cases in cases of first impression. Additionally, the serious question standard complies more closely with the underlying purpose for even having injunctions in the first place. Which brings me to my second point. The serious question standard ensures fairness, equity, and justice. The purpose of preliminary injunctions is to maintain the status quo, prevent irreversible injury throughout the litigation process, as this court stated in University of Texas versus Cambridge. The traditional standard fails to take irreversible injury into account in every scenario. For example, if there is only a 25% showing under the likelihood of success category, that injunction is automatically denied due to the dispositive nature of the traditional test using elements. It doesn't matter if that injury was at a 100% likelihood or if that injury was guaranteed death. The traditional standard does not take those into account due to one element failing. The serious question standard, being a balancing test, looks at all four of these factors simultaneously. By showing a high likelihood of injury, just like we have here, a balance of equity in favor of the movement from the severe injuries, only a serious question then becomes required. And that's why flexibility is necessary for preliminary injunctions. In cases like this, cases of first impression, in cases with limited time frames, Judges need the discretion to be able to look at all of the information they have in front of them. In this case, shown on page 1 of the record, there was only 1 week from filing suit to filing the injunction. 1 week of discovery, fact finding, and as the 8th Circuit stated in database systems versus DL systems, preliminary injunction hearings aren't meant to be mini trials. And that's exactly what the traditional test is trying to do. Using the exact same 51% preponderance of the evidence standard that would be used at trial, they're forcing the exact same fact finding and potentially forcing a judge to speculate.
So how do you reconcile winter with what you're suggesting right now?
With the likelihood of success.
Correct. And doesn't winter suggest that, preliminary injunctions are extraordinary remedies and that all 4 elements of relief must be met?
Yes, Your Honor, and that exactly goes to why the serious question standard must be used, because it does look at all 4 of these factors. Whereas in the traditional test, not all of them have to be looked at, and you can deny on one. But these mental harms that Jeff is potentially going to undergo if this injunction were denied are extremely serious. These mental harms often manifest into physical harm and even the ultimate irreversible injury, death. We aren't asking this court to move mountains. We're simply asking to let Jeff have his day in court. Because this being a preliminary injunction, there still has to be a trial on the merits. And if his remedy is taken away, there's no way he would recover. This decision echoes far beyond these parties, and for these reasons, this court should affirm the lower court decision.
Thank you.
May it please the court. My name is Madeline Gitter, and I also represent the respondents, Jess Mariano and his parents Elizabeth and Thomas. During my time, I will discuss why this court should affirm the judgment of the 15th Circuit Court of Appeals in regard to the respondents' substantive due process and equal protection claims. The preliminary injunction should be upheld for 2 reasons. First, the Stop Adolescent Medical Experimentation Act impedes a fundamental parental right. And second, the act discriminates on the basis of sex. Elizabeth and Thomas Mariano have witnessed their son Jess struggle with his gender identity from a very young age, as noted on page 4 of the record.
Your opponents say it's not sex with age. What do you do with that argument?
That point brings me into my second point, Your Honor. While petitioner may allege that the classification for the same act is age or medical procedure, not sex, those are simple clarifications that the act makes. However, the act's main hinging classification is sex. In Boston versus Clayton County, this court established that you cannot discriminate against transgender without discriminating on the basis of sex. That was a Title VII employment discrimination case where an employer fired his employee because she decided to present as a gender different than the one that she was hired as. While that is a Title VII employment case, and those are not automatically accepted in equal protection analyses, the courts have adopted that same principle in establishing transgender as a quasi-suspect class through the sex classification in equal protection claims, as seen in the 8th Circuit in Brent versus Rutledge. In that case, the state of Arkansas was attempting to pass a very similar act, the Stop Adolescents from Experimentation Act. They adopted the transgender as a suspect classification reasoning employed in Boston in shutting down the safe votes and thus subjecting it to an intermediate level review. Back to Jess Mariano's parents. They were with them every step of the way in deciding this treatment path. and to stop adolescent medical experimentation acts impede their fundamental rights. Which brings me back to my first point, that their right is being impeded.
Doesn't the state have a compelling interest to regulate the medical profession?
Yes, Your Honor, the state does have a compelling interest in overall regulation of the medical profession. However, that should not override the parental rights to direct the care, custody, and control of one's child.
So is there a constitutional right to experimental medical treatment?
There is no fundamental right to experimental medical treatment. However, that is not the right alleged here, and the fact that the treatments are experimental is trivial. While petitioner does state that the treatments are not trivial,
Why are you suggesting it's trivial?
it is trivial, Your Honor, because these treatments are used for various other conditions, for other treatments such as early onset puberty, late onset puberty. They're used for children who are developing boys who are developing breast tissue. They are used to remove that breast tissue so that he can feel more in line with his gender. And so just because these treatments are being used to treat gender dysphoria, does not automatically make them experimental.
Is the legislature in a better position to make these policy decisions than the courts?
Here, Your Honor, the state is not in a better position to make these legislative decisions. Healthcare providers are and healthcare organizations. In the numerous studies on page 7 of the record, including the ones done by the World Professional Association for Transgender Health, they advocate for these treatments for transgender minors and those with gender dysphoria. So more deference should be given to those organizations who advocate and research on behalf of these conditions and for these children.
So with any statute regulating healthcare, for which there's a health organization that goes opposite of that legislature, would it be in the same position?
Are you referring to if there are maybe risks associated with the treatment?
Well, just does the legislature have the right to regulate healthcare?
Yes, generally, Your Honor, yes. However, here that should not impede the Mariano's fundamental right to direct the care, yes.
But I don't understand why the court should substitute its judgment for that of the legislature. I think that's what my esteemed colleague is asking.
The lower court did determine that the act's findings and purposes were not in line and were not narrowly tailored to the act's purported interests. And in order to our constitutional rights at stake, the court will have to step into the legislature and overrule those legislative findings if they are depriving an individual of their constitutional rights.
So what deference would we give to the lower court?
This is an abuse of discretion case, Your Honor, and so unless the lower court were to abuse discretion and ruling that the Mariano's were likely to succeed on the merits of their constitutional claims, then this court should affirm the judgment of the lower courts.
And
And
issue the law as well? Is the standard abuse of discretion?
I believe so, Your Honor. While there are certain limits that are imposed upon a fundamental parental right where there are risks associated, as my co-counsel mentioned earlier, usually in those cases, a third-party fact finder is employed. So if the state were to allege and this court were to find that these treatments are experimental and that the fundamental parental right could be limited, the third-party fact finder could be Dr. DeGray, just a psychiatrist. In Parham versus JR, this court, whenever a state statute was allowing parents to unlawfully admit their minor children into Georgia State mental health hospitals, this court allowed a third-party neutral fact finder to account for those inherent potential risks associated with making decisions for one's child. Here, Dr. DeGray is adhering to all of the World Professional Association for Transgender Health outlines that they have given on page 7. He began just on the social transitioning and the conventional therapy. However,
But you would agree that there are some sources that suggest that these puberty blockers and gender affirming hormone therapies are not appropriate for minors, right?
there are studies which show that the treatments which are irreversible are harmful to minors. However, the puberty blocking medications and the hormone suppressing medications are all reversible treatments. And as cited on page 5 of the record, if Dr. DeGray said that if Jess were to have even 1 month of interruption from these treatments, he would immediately begin to go back into female puberty. Thus, the same act is not narrowly tailored in achieving its government interests and in safeguarding the well-being of children.
Does the state have any rights to limit parental freedom and authority when it comes to a child's welfare?
Yes, Your Honor, and this court established that in Prince versus Massachusetts, where a custodian of a child was allowing the child to sell magazines for the Jehovah's Witnesses late at night. And the state was allowed to intrude upon that fundamental parental right because there's a clear and present danger. And while there are hypothetical dangers which petitioner does allege, they are not present. Jess Mariano has received these treatments for 4 years now, since the age of 10, whenever he began to undergo female puberty. And he has experienced none of the side effects alleged by the state. And even further so, the side effects that they do mention, such as cancer, liver dysfunction, bone density issues, those are true of almost every medical treatment. So as long as doctors are adhering to the guidelines set forth in best care
So
practices,
you said all treatments have those side effects?
most medical treatments and drugs do have substantial side effects, which are long-term, not necessarily present or clear in the moment. Thus, the state of Lincoln has not narrowly tailored this statute because it over includes procedures that are not clear and presently dangerous to the children. In fact, it achieves the opposite of its purported effect. Its aims are to prevent children from accessing these treatments, which could subject them to irreversible harms.
But why is it not narrowly tailored if at 18, the person can undergo the treatments? Why is that not narrowly tailored?
The statute is not narrowly tailored as to the fundamental parental right because it does not explicitly list every treatment that is prohibited by the same act. As you can note on page 3 of the record at the very bottom, that explicitly says including but not limited to. Parents do not even know what treatments are prohibited for their children, and they cannot therefore act in a way that's in the best interest of their child. They do not even know what the state alleges is against the best interest of their child.
That's a little bit extreme, isn't it, counselor? I mean, we don't know. This is all news. So to suggest that we don't know what's out there as lay people, that sounds a little bit much to expect of a parent.
Your Honor, even the act is also not narrowly tailored though, because it does not achieve the interest of prohibiting these treatments from, it is over-inclusive and it is not the least discriminatory means available. If the government is trying to prevent children from accessing these treatments for achieving the outcome of irreversible harm, that is not being done here because they would face irreversible harm if they did not receive these treatments. In Carey versus Population Services International, where the state was banning contraceptives to those under 16 from receiving birth control for the interest of promoting safe sex, the court there acknowledged in dicta that was not even rationally related to the purpose because it achieved the opposite interest. It put children at risk of participating in unsafe sex. And so thus the act likely couldn't even pass a rational basis review. And that's not even considering the equal protection claim, which brings me back to my second point, that the act discriminates on the basis of sex. This is not an age or medical procedure-based classification because other children may receive these treatments and not be barred by the act. Sometimes the scope of the act only applies to transgender children, and thus they are receiving a disparate impact. While the gender dysphoria might be inherent or might be required in alleging that these treatments are not approved for their purpose, that's a medical procedure classification. That simply is not true. The primary classification is sex-based.
Can you tell me, are the statutes in other states that have been blocked identical to this one?
No, Your Honor, they are not identical for this one. In Hennessy Waller versus Snyder, the act there only bans gender constructive surgeries. And it was more of a Medicaid coverage case. And so the act wanted to safeguard children. However, it did so in a less restrictive way, which the state of Lincoln should have employed here. They should have only included the irreversible gender reassignment surgeries for children instead of including puberty blocking medication and hormone suppressing medication. Thus, the act is not narrowly tailored and it would not survive strict scrutiny or intermediate scrutiny.
How did our recent decision in Dobbs impact your argument? Doesn't Dobbs suggest that laws that make distinguish between medical procedures aren't sex discrimination? And isn't that what we really have here? We're just saying we can't do these certain procedures.
Your Honor, while Dobbs is this court's most recent precedent dealing with a medical procedure, the court did acknowledge here that abortion is a very unique act, and their reasoning there should not apply generally to all medical procedures. And even still, this act is relying on sex as a classification. And again, even under a rational basis level of review, the government is not achieving its important or compelling interest in passing and stop adolescent medical experimentation act. Ultimately, while the state does have a compelling interest in safeguarding the welfare and well-being of children, so do pediatricians, so do psychologists, and so do guest parents. The state should not be able to intervene onto their fundamental parental rights if the state cannot allege and prove the risks associated with this treatment, and also override Jess's doctor, and also promoting and guiding him and his family in receiving this treatment path. Jess is relying on this treatment to stay alive. Reversing the preliminary injunction would not only impede the fundamental parental right, it would put Jess's life at stake. In this situation, the state of Lincoln cannot possibly know what is best for Jess Mariano. It is for these reasons that this court should affirm the judgments of the 15th Circuit Court of Appeals.
Thank you so much.
2 points on rebuttal, Your Honors. First, the harm stated by respondents is speculative, and second, the experimental nature of these treatments are not trivial. As to my first point, respondent contends the harm claimed by Lincoln is speculative. However, so is opposing counsel's harm. Suicide and depression are complex issues that cannot be attributed to one singular thing. It would be irresponsible to argue that only the cause of a minor's depression and potential suicide could be attributed to an act of the legislature when there are societal, family aspects at play.
But if the child has said, as your colleague highlighted from the record, that he took pills and did not want to wake up as a female, that's pretty convincing, is it not?
Your Honor, that as cited on page 4 of the record took place before Jess Mariano was ever in any sort of psychotherapy or any sort of psychological treatment for his gender dysphoria or his depression. As to my second point, the experimentality of these treatments,
So we just discount it, I'm sorry, back up just a little bit. So we just discount the fact that Jess presumably wanted to take his life.
no, Your Honor, we do not discount it. However, there are a myriad of reasons that leads to a child, especially a child of only age 8, to want to do something as permanent as that. And that cannot be attributed to merely one factor. And as previously stated, this was before any psychotherapy whatsoever was provided to him. I see my time has expired.
Thank you so much.
Everyone, we are going to leave the room.